Hear, all persons having business with the appellate are here, give the attendance, shall be heard. Please be seated.
Good afternoon and welcome to the Appellate Division First Department. We have over 7 hours of argument time that has been requested, so we'd like to ask you to please just ask for the time that you really need. Remember, we have had your briefs in the record, and we are familiar with your cases and just would like you to hone in on the important issues and, of course, answer our questions. When the white light goes on, that means you have 2 minutes left. When the red light goes on, please finish up your question, your sentence. And if we have additional questions, we will continue to ask them if we feel it's important. So we're going to call the calendar now. Both sides, please stand up, and appellant and then respondent tell me how much time you are requesting. First case on the calendar, People versus Chapman. Okay. 4, 1, and 4. Thank you. Escobar versus New York City Transit. Well, they appear not to be, so we will take it on submission. Thank you. Dionisio versus Albania is submitted. Gill versus B.K. Bryant.
Defendant appellant requests 5 and 2, please.
Okay, and respondent? Okay, 5, 2, and 5. Thank you. 513 West 26 versus George Bill's Galleries. Respond. Apparently, the appellant is chosen not to be here, I've been told. Did you want to argue? Oh, we'll give you 3 minutes, and if we have anything more, so it'll be a submission in 3 minutes. People versus Antonio Gonzalez is submitted. People versus Natasha Foreman is submitted. IBT Media versus Pragad.
For the appellant, 7-2, Your Honor.
Okay, and respondent? Okay, 7, 2, and 5. Thank you. Westman Realty versus Nettles. Okay, and respondent? Good. Okay, 7, 2, and 5. Thank you, Counselor. Hersani versus Extel 4110. Okay, 5 and 3, and respondent? Okay, 5, 3, and 5. Sorry, point of the pencil just broke. People versus Wilson is a submission. People versus Sanchez. Okay, 5, 2, and 5. People versus Patrick. Submitted. Murphy versus Chinatown Cardiology.
3 minutes, it's no respondent.
No respondent? Okay, you can have 3 minutes, certainly. Barone versus Clopton. Submitted. People versus Simmons is submitted. Satterfield versus B-Stock Transfer. Okay, and respondent? Okay, 5, 2, and 4. Warburg Realty versus Ashheim. 5 and 2. Okay, is there a respondent? Do you still want a few minutes to argue, or you want? 2 minutes. All right, we'll be happy to give you 2 minutes. No respondent. People versus Santos.
Appellant requests 5 and 2.
Okay, and respondent?
Respondent, 5.
Okay, 5, 2, and 5. People versus Rockford.
Appellant requests 3 and 1.
Okay,
Respondent, 4.
we got it. 3, 1, and 4. Owens versus SD Trucking is submitted. Okay, that completes the call of the calendar. The first case for argument, People versus Chapman.
Step up.
Good afternoon.
May it please the court, Stephen Chu on behalf of Mr. Demetrius Chapman. This case warrants nothing more than the statutory minimum. In the summer of 2016, Mr. Chapman deposited a few postal orders that were forged. The evidence shows that he was not the one who did the forgery. There's no evidence, no allegation that he withdrew money from these forged deposits. By all accounts, it seems like this was a temporary job. And he walked away from this gig a long time before his arrest in this case. As the Supreme Court has said, this kind of crime is one of the most passive, quote, felonies a person.
What do we make of the fact that your client failed to appear for sentencing?
Exactly. That's a good point, and he should have come back. That's not an excuse.
Well, how should we assess that in determining whether or not it's a fair sentence?
Yes, so two responses. First, the circumstances that was going on. The record shows that he had lost his grandmother, his cousin, his nephew, all in the span of a short time. He was rebuilding his life with a young family, a young daughter, and he should have come back. When he did come back, the health department at Rikers diagnosed him with depression. So that's the circumstances that we have in the record. But from a legal standpoint, the question before this court is whether 3 to 6 years, the statutory minimum, was appropriate for what happened here. And that's why I was starting with just how minimal the nature of what happened here was.
So what was he facing? What was the maximum aggregate of the sentence?
The maximum that he was facing, I think
10 to 20, correct? 10 to 20?
I think that's right. And the prosecutor, even at that point, asked for 5 to 10.
And he got a sentence of 3 to 7, 3.5 to 7. Isn't that sort of in between, in the middle somewhere?
It is, and I think that's why this case is a really good case to think about what the...
And he comes back because he's arrested. It's not that he voluntarily returned. He's arrested for possession of, well, he may have been charged with selling, but he ultimately takes a plea to criminal possession of a controlled substance.
Yes, he comes back on...
It's a misdemeanor plea.
It's a misdemeanor plea. He was given a sentence for that. It was run concurrent.
But of course, probably it would appear that a large part of the defendant's treatment stems from the fact that he's a second felony offender with the prior violent of attempted murder.
I think, Justice Friedman, that's exactly our point. That this sentence, if he had come in as a first-time felony offender, probably warranted probation.
But he's not a first-time felony
Exactly,
offender.
and that's why the minimum...
He's a prior violent felony offender who then warrants at the time of sentence on this plea.
To be clear, he got the minimum in his prior case, but that's why his sentence has already been enhanced to a minimum of 3 to 6 in this case.
The people wanted 5 to 10 on this, didn't they, when he was brought back?
Yes, and the facts of this case do not say that 3 to 6 is the thing that matches what his culpability is in this case. If this was a money order, if this was a check, the minimum would have been 2 to 4. If this was his first-time offense, he could have gotten probation. He's facing a minimum of 3 to 6. That's the statutory minimum allowable for this category.
But Judge Edwards seems to have been really careful in terms of what sentence she, in the face of the people's request of 5 to 10, the original plea agreement of 3 to 6, is warranting a time of sentence. She really didn't raise the sentence for his non-appearance by a whole lot.
Because the original sentence of 3 to 6 is already harsh. It's the lowest that the plea could have gone because it was the statutory minimum. But 3 to 6 for cashing a few postal orders is a harsh sentence. And we're not arguing that you should go lower than 3 to 6.
Those money orders were for $20,000, were they not? But only $15,000 were in the New York jurisdiction?
It was for $1,000 each, and there's no evidence that he actually got any of that money. If I may finish this response.
Just finish your answer, sure.
He did not get any money. The circumstances below are minimal, and 3 to 6 is already a harsh sentence for this offense.
Thank you.
Good afternoon, Your Honors. John Hughes for the people. Here, under the original plea agreement, the court was going to sentence defendant to the statutory minimum, but that was before he did not appear at sentencing. That was before he was rearrested for committing a new crime in Brooklyn. And so under those circumstances, we think it was absolutely fair and appropriate for the judge to...
The nature of this crime doesn't result, I don't think, in a sentence of 3 to 6, typically.
Well, obviously, it depends on the individual circumstances of each case. But for criminal possession of a forged instrument with the intent to defraud, the sentencing range here was for predicate felons such as defendant, 3 to 6 on the low end and 7.5 to 15 on the high end, just for one count. But of course, here there were ultimately 15 different counts involving separate money orders.
But yet he wasn't the mastermind, right? You would agree? I mean, he was a low-level guy depositing the checks.
Well, this is a plea case, Your Honor, so obviously there wasn't a trial with a full description of the underlying facts, but here he pled guilty just to one of these counts of criminal possession of a forged instrument, which indicated at a minimum that, he admitted he knew that it was forged and that he possessed it with the intent to defraud and defraud others. And note too, again, just in Manhattan, there were 15 separate forged money orders that he deposited on 7 different dates at 3 different banks all across Manhattan. And so for just the money orders that were deposited at Manhattan banks, we're talking about a total of $15,000. So this was a fairly significant monetary amount in total. And so we would submit that for all those reasons, the court sentence of 3.5 to 7 years was absolutely appropriate. And in fact, that was still very, very close to the minimum sentence in this case. I would like to also just quickly note that in my adversary's reply, they're correct that for this Brooklyn case, that case preceded by superior court information, not an indictment. So our footnote to that effect should have said that. But if your court doesn't have any other questions, then we would rest on our brief and ask that you affirm. Thank you.
Thank you. Counsel, you have a minute.
Briefly, Judge Singh, the prosecutor asked for a handwriting sample in this case. It came back negative. They did some investigation. He was not the forger. And I think the prosecutor's arguments crystallized why this is it.
Counsel, right? There were you're saying that the signatures, what were you saying about the signatures?
The prosecutor asked for a handwriting sample from our client. They went back. They didn't charge him with forgery after that.
I understand now.
This case shows an interesting question about the purpose of punishment. Is 3 to 6 years enough for what he did in this offense? Obviously, he should have come back to court. He was struggling. He should have come back. But given what happened in this case...
What do you think a judge is supposed to do when there's a sentence date and the defendant just doesn't return at that time?
Yeah, I don't think there's any obligation for the judge to provide more time. The prosecutor could have sought a bail jumping charge if they wanted to, but because of the facts of this case was so minimal, and again, I think it's important to know, he didn't choose between bank order or postal order or check. He took what was given to him, he cashed it, he didn't take any of that money, he cashed it. Giving him more than 6 months to a year just doesn't satisfy what we think of as punishment for this case. We respectfully ask this court to reduce the sentence to the minimum. Thank you.
Okay, thank you. Thank you both. Gill versus B.K. Bryant Avenue.
Good afternoon, Your Honors. Michelle Russo on behalf of the defendants' appellants. The order below, we respectfully contend, should be reversed on the basis that the questions of fact that the court found are not actually legitimate, considering various factors in the record, which I would like to go through. Number one, in this storm in progress case, it's not a legitimate factor. It's when you consider the fact that the plaintiff was the only person who was present at the scene to testify concerning what the weather conditions were at the time of the incident. And that testimony, according to her, was that it was snowing heavily, and there was approximately 6 inches of snow on the front steps where she fell.
But the snowfall, the snowing ended about 6 hours, substantial amount of time before the accident, correct? It wasn't a storm in progress at the time of the accident.
There was snowfall that continued from the evening before and ended at approximately 12:35 in the morning. You're correct, Your Honor.
So again, just to be clear, it's not a storm in progress.
Well,
and you can't rest on that doctrine, can you, on this record?
Well, we can, and I'll explain why, Your Honor. The only evidence that there was ostensibly no storm in progress, given the testimony of the experts,
doesn't
should not have been.
Meteorologists say the last time there was snow accumulation was 10 hours before plaintiff's fall?
That's what he said, Your Honor. However, there's no actual records in the record to support that testimony because the experts never submitted with their report the data that they relied on to draw that conclusion. It was excluded from the record. Additionally, there was a video that was that experts relied upon, which was also not in the record. And that video, which purported to show the conditions of the sidewalk area, which is not where she fell at the time of the incident, was also not part of the record. And I refer the court.
Assuming there was snow in progress, arguendo, would you agree or disagree that there is an issue as to whether the owner caused and created by virtue of remediation? In other words, when there's evidence of record that work was done before to clear and put salt down, and so there's an issue of whether that particular activity could have created or exacerbated the conditions of the step.
Well, I think that's a speculative issue, in which case it's not an issue.
I thought that Mr. Diaz, who is the building super, testified that on the day of plaintiff's accident, he woke up between 4:30 and 5 in the morning, and he threw extra salt down. So he was involved with doing something there. He says he didn't notice ice or snow on the steps, but he did do something to try to remediate the situation by throwing extra salt. So doesn't that sort of make it a little confusing here as to what actually happened, at least raise an issue of fact?
Well, I disagree, Your Honor, for two reasons. First of all, we have the plaintiff who sues the person who was there, who sues my client, who says that these were the conditions. Mr. Diaz was not present at the time of the incident. Yes, he testified that he had
Well, he
put
got
down
up
some
that
snow
morning.
approximately 2 hours before. There's no evidence that there was any condition on the steps that he had created. There's no notice to us. In fact, if his testimony were to be believed, we still win. If plaintiff's testimony is to be believed, the case should be thrown out. If defendant's testimony is to be believed, also should be thrown out because steps were taken, and therefore the conditions were not as stated by the plaintiff. And again, I go back to the expert's report, which should not have been considered at all, which the court actually did consider. And I refer the court to the decision in Pearson versus North Colony School District, which we cited, which is at 7483rd, 1652, where the precise issue existed in a snow and ice case where the plaintiff's expert, in fact, the very expert that's involved in this case, did not submit a report indicating what the conditions were at the time of the incident, and he neglected to submit the data that supported that, if I may just finish, and he neglected to submit the data that supported that, and the court rejected the affidavit.
Okay, you'll have a couple minutes on rebuttal. Thank you.
Good afternoon, Your Honors. May it please the court, Kenneth Gorman for the plaintiff respondent. With regard to Mr. Diaz's testimony, he testified that he arrived at the scene shortly after the incident. If you go to page 209 of the record, he states at the bottom, towards the end, is that video a fair and accurate representation of the front of the building as it appeared that morning between the hours of 7:30 and 8:30 a.m.? He response is, it's 100% accurate. This video, I mean, was never in dispute. The contents of the video was never in dispute.
What about counsel's point that the meteorological reports did not include the backup material?
If it happened that way, it was an accident. Because if you look at their reports, they refer to the certified records, and they refer to it as exhibits. I think it was D, E, and F. They referred, it was an inadvertent mistake.
Was it ever submitted to the court below?
It was never, they never argued it. They never took issue with it. This issue, her argument that these records weren't submitted, it was unpreserved. Had it been raised at the appropriate juncture, we would have submitted it. I didn't realize.
Isn't it your obligation in the first instance to put in the records? I mean, it seems pretty simple.
That's true, but it was an accident. It was inadvertent. Also, in HERA, which my adversary relies on, cites in a reply brief, and she says that we don't distinguish it. In that record, Brian Isaac, although he argued the case, I wrote the brief, and I was looking through the record last night. There were no certified records in that case. The point is that this is not an issue that comes out in the face of the record. Had my adversary raised it at the appropriate juncture, we would have corrected it.
Counsel, was there a counter? Were there meteorological experts who testified on behalf of, or who provided, affidavits on behalf of the defendants?
No. In this case,
Yes.
the defendants submitted no meteorological records in support of their motion or in reply.
So then how do you respond to the argument that your client testified that it was snowing, so storm in progress applies?
I mean, well, that's it. In HERA, they said it was the same situation. The plaintiff testified that it was snowing, but in opposition to the defendant's motion for summary judgment, she submitted her affidavit from the same meteorologist in this case, which was sufficient to raise an issue of fact with regard to the conditions of the area that she fell on at the time. And also, when we look, there's a reason why they didn't submit Mr. Diaz's testimony, because it establishes that it was not snowing at the time. He authenticates a video, and he says that the area shoveled, he salted the area before the incident, he took measures, and there was no indication from that video and his testimony, he was actually there. There was no snow at the time. At the very least, it raises a question of fact. Thank you.
Thank you.
I'd just like to point out the Herrera case that counsel mentioned, we cited for a different proposition, and that was that the plaintiff's testimony alone was sufficient to demonstrate prima facie entitlement to summary judgment. And I understand, of course, that the result was different, and I believe that we acknowledge that in the papers. With respect to the video, going back to that, which was, again, not part of the record, there was a video that the experts looked at, and there was also a video that Mr. Diaz authenticated, no question about that. There's no evidence, however, that that's the same video, that we're looking at the same thing. The experts don't say this was the video that he authenticated that was marked at his deposition and that he testified about. So it's an open question as to what the video was that they looked at and what, in fact, it represented.
But at the end of the day, counsel, are you relying on the snow in progress doctrine or not?
Absolutely, Your Honor.
But your own person said, Mr. Diaz, that he didn't notice snow or ice on the steps.
And alternatively, if in fact the plaintiff's testimony is disregarded, our point is that there's still no notice.
So there's an issue of fact, isn't there?
No, because under one circumstance, if it was snowing, the storm in progress doctrine applies. If it was not snowing and a sufficient amount of time had passed, and that's another issue that the plaintiff never addressed in terms of what was sufficient. And if you use the administrative code as a guideline, and you look at when the storm ceased, then we have 4 hours beyond that time, which would bring us to 11 a.m. to take any.
But the superintendent nonetheless testified that even though he didn't see snow or ice, he threw salt down.
Right, but that doesn't create the condition, number one, and number two, Your Honor.
It creates questions, doesn't it?
Well,
as to what was really going on?
It doesn't, because if that scenario is believed, Your Honor, then plaintiff still can't make out a prima facie case of negligence. That's our point. So under either version, there's no case to be made against the defendants.
Okay.
Thank you, Your Honor.
Thank you both. 513 West 26th. We have just the respondent here, right? Good afternoon.
Good afternoon, Your Honors. My name is Mary Ryan Bambrick for the respondent. If it pleases the court, in your review of the constitutionality of the guarantee law, I'm respectfully requesting that you consider for your independent review the dissenting opinion of Judge Carney in the Second Circuit decision in Melendez, where the majority remanded the Contracts Clause question to the district court. Judge Carney felt that the majority was asking the district court to apply a strict scrutiny standard rather.
Shouldn't we, in this case, as we have actually in a couple of prior cases, just remand for a, because clearly there was a problem with notice. The city wasn't put on notice, which does violate the CPLR. Shouldn't we just remand and allow a full record to be developed on the constitutionality as to whether the elements have been met, and then have the court decide, and presumably then it comes back up here?
Yes, but what Judge Carney felt was that the majority was asking the district court to apply a strict scrutiny standard.
We understand that, but that is, I mean, as you pointed out to us, that is the dissenting opinion. That's not what the majority
But what
found.
Judge Carney felt was that the strongly deferential standard was in line with Supreme Court precedent.
So, counsel, let me put it a different way. CPLR 1012 says that the city must be notified when the constitutionality of a statute is an issue, right? So how do you get around that? It's shall language, it's mandamus language, isn't it? Is this matter, how can this matter be ripe for our review if the city has to be notified and provided an opportunity to defend a statute that was passed by the city council? Or in part of the administrative code 22-1005.
But in Judge Carney's felt that the Supreme Court and the Second Circuit used the deferential standard for legislation facing.
You don't have a response other than to cite to a dissent?
Well, in this case, that the standard that they used, that the district court used, was not the standard.
But before we get to the standard, don't we need to understand the facts as to the basis as to why the city council passed this and allow the city an opportunity to develop a record on the issue, applying then whatever the right standard is to make a determination as to the constitutionality?
In this case, though, the guarantee law was in effect, and during COVID, and the guarantee law.
Yeah, but the constitutionality of it has certainly been brought up, and it would seem that we have to develop a record and that we had an obligation, that there was an obligation to allow the city notice and an opportunity to respond. All right, well, I think we got your point, and you're just sort of going a little bit round and around. Thank you very much for pointing that out to us, and have a nice afternoon. The next case for argument is IBT Media versus Pragad.
Would your honors mind if my colleagues sat up here?
Oh, that's okay.
Thank you.
Can I have reciprocity on that, Your Honor?
Do you have a colleague that wants to sit up there? Well, sure. That's why there were two chairs.
May it please the court. My name is Michael Hefter from Alston and Bird on behalf of Appellant IBT Media. In this case, the IAS court made several significant errors in dismissing the complaint that we filed on several grounds at the pleading stage of this case. In fact, I'll start off by describing what we believe is the fundamental false premise that Justice Crane used in starting the analysis. And that is, she conflated the relief and claim that we were seeking in count 1 of the complaint and the count 2 of the complaint. And in fact, what she did was dismissed count 1 of the complaint based on the merger clause in the membership interest purchase agreement, the contract at issue, and section 5. But our point in count 1 was that the entire transaction was a sham.
But the entire transaction couldn't have been a sham because clearly there was an agreement to transfer the property, right? So that part of it is not a sham. You're saying that you're entitled to the property back. That part you're saying is a sham, but not the entire contract. Is that a fair statement?
Respectfully, no, Your Honor, because we believe the entire contract is a sham, and we believe that there are multiple cases in the state, including the Kritzer case and the Archer case, in which after a transfer occurred and stock certificates were transferred, the party seeking to unwind the transaction claimed it was a sham, and the court allowed parole evidence.
Yeah, but in this instance, the MIPA is not ambiguous. It clearly and expressly allows for the transfer here. What you're claiming, arguendo, or among the pleadings, is that there was an oral understanding, a promise that once the indictment issue gets resolved, then I'll get my stuff back. But that could easily have been put into the MIPA, correct? Couldn't the plaintiff IBT say, you know what, on such and such date, when my issues get resolved, you give me my stuff back? You didn't put that in the agreement, correct?
I have a number of different reactions to that. You're right, it's not in the agreement. That was a fact that Justice Crane relied upon.
Could there have been some type of side agreement that you could have entered into separate and apart from this agreement? Because we see those sometimes.
We believe there was a side agreement. In fact,
An
it was
oral side agreement.
Side agreement.
That's
correct.
defeated by the merger clause, correct?
No, Your Honor, it's not prohibited by the merger clause. I'm sorry. It would be prohibited by the merger clause if the MIPA itself was deemed to be enforceable. But based on all of the facts, which the IAS court did not recognize, she used that to, at the pleading stage, and not admit parole evidence, as we are entitled to under the authorities under the sham transaction theory, to introduce into evidence to show that the entire contract was a sham.
So here's the question that I have. You're talking about shares in a very, very valuable property, right?
Correct.
Right, you're talking about Newsweek. I mean, this is like, this is big, right? Okay, so you have sophisticated parties on both sides, and the sophisticated parties say, this agreement is the entire contract between the parties, and this is the part that I'd ask you to address, and it supersedes all prior and contemporaneous agreements and understandings between the parties. So you're saying that that wasn't real, that was a sham, that was fake, that was to get around the fact that the owner of IBT Media was under indictment, and therefore this is like, oops, I signed it, but I didn't really mean to?
Well, no, Your Honor, because that would be considered a general merger clause, and under the Court of Appeals decisions in Dannon Realty and Plappinger and other cases that we've cited, we don't believe that that would prohibit, the general merger clause would prohibit the introduction of extrinsic evidence to show that that there was fraud in connection with the procurement of the entire agreement. And it goes back to my original point, which is if there was fraud to induce the entire agreement, then all the provisions go away. And if it was a sham...
If it was a fraud, in the way you're describing it, it was a fraud on the DA's office, wasn't it? And so wouldn't that in itself be sufficient? I mean, you have unclean hands coming into the transaction saying it was an entirely sham transaction and I want my property back.
Well, Your Honor, I'll point to several allegations in the complaint where we allege that the DA was made aware and didn't object to it. So it was no fraud on the DA's office. And in fact...
Right. They didn't object to the transfer, right? Because there was an agreement to transfer Newsweek to the defendants. So why would the DA object to that? What you're saying is that this entire transaction was a sham, and there was never any intent for plaintiff to let go of his property. That was his property.
Well, Your Honor, it's because from multiple decisions of this court and the Court of Appeals have established that it is entirely proper to have parole evidence be introduced.
So what facts did you allege which show that you didn't mean to enter into an enforceable agreement?
Your Honor, there's multiple allegations in the complaint that, first of all, Mr. Brigade represented that the transaction was not real. The entire circumstances, Mr. Brigade.
But you did in fact transfer the interest.
And our position, Your Honor, is that the actual transfer of the interest, if you look at the opinions of this court, is irrelevant to determine whether there was, in fact, whether the transaction was not real.
I mean, it seems to me that you did want to do a transfer. You just didn't want it to last forever. You wanted the property back. So it doesn't seem like it was a complete sham that you weren't intending to transfer it because there were reasons that you specifically were planning to transfer. You just thought it was going to be, you thought that there was a side oral deal that you would get it back at a certain time. And Mr. Brigade at some point said, well, no way, you're not getting it back.
Except, Your Honor, Justice Kaepernick, that ignores all of the allegations of the complaint where there was no consideration actually paid for the transaction. Mr. Brigade sat on both sides of the deal. He directed all the attorneys on how they did it. And
he directed the other side's attorneys? Mr. Brigade did?
Well, Mr. Uzak did have counsel, but if you look at the actual allegations of the complaint, which are required to be accepted as true at this point, and in fact, with respect to the sham transaction theory, and what Justice Crane did was she drew all the negative inferences against my client, including suggesting that this was a fraud on the DA, which we don't believe. It was in order to, I mean, the whole purpose of the transaction.
You allege that you did speak to the DA and that there was...
Right, and those allegations need to be true, and Justice Crane, beyond the legal error of conflating the two claims, never accepted those facts as true and drew all inferences negatively against us. So on this record, at the pleading stage, my position is that our case should have been allowed to go to trial because these issues, extrinsic evidence was allowed to be introduced, and the case should be decided on a full factual record.
Counsel, if I'm not mistaken, did anything survive her decision? Any other causes of the action? Because
yes.
I don't believe this is a total wipeout, correct?
Well,
she allowed you to replead the 6th and 7th causes of action, is that correct?
I believe it's the...
So then this case isn't over yet.
6th and 7th.
Right, so the case isn't over, right? Arguendo.
No, it's not, Your Honor, but based on the factual record and based on what we've pled and based on the relief that we're seeking, we believe that there should be a rescission of this agreement and my client should get the return of the asset.
Okay, let's hear from your adversary and we'll give you a few minutes. You'll have a few minutes for rebuttal. Thank you, counsel.
Good afternoon, Your Honors. Virtually everything they say about a sham, this being a sham transaction, is contradicted by the express terms.
Oh, so you get a asset that's worth, if I recall correctly, $2.3 million for $5,000. These are the allegations of plaintiff's complaint, which I accept for the purposes of the motion to be true. You reduce the intercompany debt from $9 million to $1.5 million, I think. It doesn't seem to make much economic sense. It does seem maybe there was some sort of, that it was an attempt to defraud the DA's office only, what was going on.
I walked by my subway stop the other day, and I noticed that where there used to be a newsstand, there is now a company that sells cell phone accessories and candy. What Your Honor is missing is that Newsweek sold for $1, and the assumption of liabilities, when the Washington Post sold it, it sold for $1. And the guy who bought it, Mr. Harmon, accepted all of its liabilities. That's what happened here. They were faced with a situation.
But wasn't there a valuation of the company that was like 2.3 million?
Yes, Your Honor, I think there was, but let me perhaps
Are you
read.
saying that there was such a valuation, but it wasn't real, and that everyone knew that Newsweek wasn't worth anything like this at that point?
They were trying, exactly, there was
Because,
an express
one
statement
is
in the
as you look at
contract.
this, and
Sorry, Your Honor.
how do you end up with a sales price of $5,000? How does the plaintiff agree to a sales price of $5,000 for this half interest of Newsweek when it's supposed to be worth more than $1 million or $2 million?
I think the important thing, Your Honor, is that they got an agreement to possibly pay, and in fact, in reality, it was paid, $1.5 million of their debt. They also assumed
Have you paid that,
tax
have you
liability.
paid that debt back to the plaintiff, the 1.5? There was a,
We have a separate lawsuit against them where we're claiming for about $20 million of things we had to pay. We had to pay their tax liabilities and everything. So yes, we have paid that back. But I just want to point out in the record that there is.
In other words, you paid more than $5,000.
We paid more and we're trying to get it back. But the purchase price is, there is a provision in the reps that says seller is familiar with and at all relevant times have had access to the books and records of the company for purposes of determining the adequacy of the purchase price. Seller further acknowledges and agrees that the purchase price was fully negotiated between seller and buyer and based on the current balance sheet of the company's past, current, and projected profit and loss statements, and the independent valuation of the intellectual property of the company prepared by UHY advisors. The purchase price is fair and adequate consideration for the membership interest. That's stated at 105 of the record. It's a rep they made, and a parallel rep is actually on the buyer side, where they say roughly the same thing. This is a negotiated term. Both parties agreed to be bound by this agreement, and that's something that they seem to ignore. If you look, starting first in the preamble, it says, in consideration of the foregoing recitals, the mutual promises, and other good and valuable consideration, the receipt and sufficiency of which are hereby acknowledged, and intending to be legally bound. Then in paragraph 5, where you have the seller's rep, 5B says, this agreement has been duly executed and delivered by the seller and is a legal, valid, and binding obligation of the seller, enforceable against the seller in accordance with its terms. Then if you flip to the actual assignment of membership interest, it also says, this assignment is made pursuant to the terms and conditions of the membership interest purchase agreement and shall be binding upon the undersigned, its affiliates, successors, transferees, and assignments.
Could you address the issue of parole evidence, counsel, because that you didn't bring up?
Excuse me, Your Honor?
Could you address the issue of parole evidence because you did not reference the agreement in all the different paragraphs that you just recited? I'm looking at the record at 108 where it says no oral modifications.
Yes, Your Honor. This is exactly the situation that you have in the Citibank versus Plappinger case and in the Dannon case. There is an integration clause in here which says very plainly that this shall constitute the entire contract between the parties pertaining to the subject matter herein and supersede all prior and contemporaneous agreements and understandings between the parties with respect to the matters set forth herein. But we're not just relying on that because there are these other provisions in here where they say, and they represent, not only is the purchase price fair, but that they have the consummation of the transactions contemplated hereby will convey to buyer good title to the membership interest being sold to buyer. Pursuant to this agreement, free and clear of all claims or restrictions, except for those disclosed on Schedule 5A, which are some tax liens, and that may be imposed or applicable. They, throughout this agreement, as in Plappinger, they have set forth statements that are unequivocally not true if you believe their version of the events. And what Plappinger says is that this court should not countenance.
Well, I mean, they're claiming under the fraudulent inducement claim, which is what I seem to keep going back to, is that at the time that the agreement was entered into, Mr. Pragad did not intend to ever give the the ownership interests back to the other people, so, to the plaintiffs. And that's really, what fraudulent inducement is about. How on this motion, 3211 motion to dismiss, can we just throw that out?
Because they have disavowed the very thing that they're claiming in this agreement. And as in Plappinger, you can't, in other words, Dannon says, first off, you could say no oral representations, and that would be enough. And Plappinger, Citibank versus Plappinger says, well, you don't have to have the magic words if the substance of what they say in there contradicts what they're claiming now.
And so what does it contradict?
Okay, well, I would point Your Honor to the seller warrants and shall defend title to the membership interest conveyed to buyer herein under any claims of all persons. And if you look at, that's on 5105, and if you look at sale of the membership interest, it says, hereby seller agrees to sell and buyer agrees to buy all of the membership interest free and clear of any and all claims, liens, options, charges, taxes, security interest, restrictions, or encumbrances whatsoever. That's an express statement in the document that we are getting good title, free and clear of any restrictions. So they can't now come in and say there were restrictions.
I'm sorry, so any so-called promise, to pick up on what my colleague raises with you, it's just rendered academic, if there was any, by virtue of the merger clause.
Yes.
That's it, it's over.
I agree.
And there can't be fraud.
There can't be fraud because everything that they say we said is contradicted by the express terms of the agreement. No parole evidence at this point. And as Justice Singh said, this is really an attempt to just enforce part of the agreement. There's no dispute that there was a signed membership agreement conveying the membership interest. What they're complaining...
Is that why it takes it out of the cases involving sham transactions? Is that the distinction between the two?
What the Court of Appeals said in Bersani was that you can't come in and just add a provision. There has been a transfer. There's no question about that. What they're saying is there should have been a provision in this contract that said that you have to give it back. Now, that provision...
I mean, they actually transferred their interest.
There's no question they transferred their
interest. And now they're saying that there is a provision, which is not in the agreement, that you get it back.
Right.
And why wouldn't that be in the agreement if that was the agreement?
It could have been in the agreement. It could have been in a side agreement. There's no question that these two parties were represented by counsel. This document was signed by not only Mr. Pragad on behalf of NW Media, but by both Mr. Uzak as the president and also by unanimous consent of the board of directors of IBT, which happened to be, those two individuals also happened to be the two shareholders of IBT. Everybody signed off on this deal. And the other thing I just want to point out is that even if what they...
all right?
Sorry?
Just finish up your thought.
The last thing I'd like to say is that they told the Manhattan DA about the transaction and he did not object. If in fact what they said were taken as true, and I don't think it can be given what's in the agreement, it would be a fraud on the Manhattan DA to have told him that you were going to do this and then come up with a secret agreement somewhere behind it, that when the coast is clear, when things cool down, that it's going to be reversed.
Okay.
Thank you, Your Honor.
Thank you.
Briefly, Your Honor, on that last point, that is the entire reason why the sham transaction issue is here, because that inherently, based on the alleged facts, is a factual issue. In fact, opposing counsel just injected a factual issue as to what the purpose of that was and whether it was intended to mislead the Manhattan DA. It wasn't, as we allege. And in fact, what we allege is that there was a complete commercial purpose to shield Newsweek from unwanted media attention and to maintain that relationships with other third parties who are doing business.
So would it have defeated that purpose to have put into this agreement some provision that says when things come down, you can get it back, or I plaintiff can get this back?
It would not be consistent with the understanding of the parties, Mr. Purgad, Mr. Uzak, and Mr. Davis, to include a provision like that in the agreement. So that, to me,
That's in the agreement. But what about a side letter agreement?
again, we allege that there was
Oral agreement,
But it was
but we're going in circles now because we go back into the agreement. So the question I have is what my colleague asked your adversary with respect to fraudulent inducement. What do you say are the facts you've alleged that back in, I think it was 2018, that Purgad had no intention of keeping his promise? What facts do you allege in the complaint to support a fraudulent inducement claim?
we allege in great detail, I think it's from paragraph 68 to 81 of the complaint, which alleges the entire lead up to the execution of the MIPA and Mr. Purgad's secret plan to maintain control, leveraging the Manhattan DA's investigation. All those facts that we allege in multiple paragraphs of the complaint show that Mr. Purgad at the time had an undisclosed plan that he hatched later to maintain control over Newsweek. Your Honors are intimately familiar.
And he made the agreement, he didn't intend to keep it.
That's correct, Your Honor, and that's a fraud claim. Your Honors are very well familiar with Dannon Realty and Plappinger. Many cases come up to this court on that issue. We believe that those cases are controlling, but they don't apply in this case. The provisions that opposing counsel cite to don't even come close to the disclaimers that are included in Plappinger and in Dannon Realty. And in fact, Dannon Realty is very clear that we're outside of that if the allegation is that the entire contract, including the provisions that we're focused on, was a byproduct of fraud. At the end, Your Honor, we have a case that was dismissed on the pleading stage on a sham transaction theory, which is well accepted in this court, in these courts for over 150 years, a fraudulent inducement claim that's well pled at the pleading stage, and we have a case in which an individual orchestrated this, as we alleged, to take an asset that's worth multi-million dollars based on the valuation, which was only the IP, Your Honor, as we allege. It wasn't the whole company. And we're supposed to believe that he selected a purchase price of $5,000 for this, and everybody believed this was real. This is a case where, if you take the IAS court's reasoning, it denies a remedy where a remedy screams out for rectifying what we believe is an improper transfer of a valuable asset based on fraudulent inducement and the fact that the whole transaction wasn't real. Thank you.
Thank you. Thank you both very much. Next case for argument is Westman Realty versus Nettles. Good afternoon.
Good afternoon, Your Honors. May it please the Court, my name is Adina Glass of the Abramson Law Group, and my firm represents the plaintiff appellant, Westman Realty Company, LLC. The appellant does not dispute that the respondents can litigate their substantive defenses, but submit that the proper forum is only in the DHCR.
In other words, you can raise your claims about rent, even though you chose Supreme Court as your forum, but that the tenants are relegated to go to DHCR. I don't see what that serves in terms of judicial economy, for example, where all the issues, which are totally intertwined, be decided in one forum.
Respectfully, the rent overcharge and stabilization claims should have been submitted to the DHCR approximately 5 years ago, within the past 5 years.
But they weren't. So you chose to bring an action here. So why shouldn't the tenant be able to assert defenses and counterclaims to your claim for rent?
They're entitled to submit their counterclaims and affirmative defenses, but the particular ones with respect to the rent overcharge and the rent stabilization should be submitted to the DHCR, not the.
Why?
It's
not res judicata, right?
I'm sorry?
Not res judicata. It's not law of the case. I guess collateral estoppel, which you're arguing collateral estoppel, that was an issue that was decided already, and therefore they're stuck with that and they have to go to DHCR, right?
Yes, we submit that that it's similar to law of the case. We understand that there are 3 cases at hand, but it's also that the allowing the respondents to submit these claims in this forum before the Supreme Court is tantamount to saying that it's acceptable to deliberately disregard the orders that were submitted beforehand.
Yeah, but I'm sorry, didn't the HSTPA make it clear that the Supreme Court and DHCR has concurrent jurisdiction? And the Chiazzo case by the Court of Appeals also made it clear that they have concurrent jurisdiction. So that's sort of, you have statute and you have appellate case law that kind of renders the original 2018, 2019 decisions, I guess, wrong.
Or obsolete.
Absolute, right.
Well, the 2019-2020 decision by Justice Perry.
Oh, I'm sorry, I meant.
Was we're calling it, I think we're calling it the same thing, but different things, but meaning the same thing, was issued after the HSTPA, and the judge was well aware that the HSTPA existed and took that into account. However,
I'm sorry, but didn't the Chiazzo case come after that? He ignored the Chiazzo case, which said there was concurrent jurisdiction.
I'm sorry.
In 2020, the Court of Appeals made clear that based on that court's understanding of the HSTPA, which you claim Judge Perry was aware of in the 2020 decision, Judge Perry ignores a Court of Appeals precedent that's binding on him, that renders and allows the tenants here to be able to assert their counterclaim for overcharge in the very action you commenced here in Supreme Court.
I honestly don't have an answer for you, Your Honor. I'm sorry. I don't know what I don't know what Justice Perry was thinking, but and how the Court of Appeals case affected his decision. I don't.
But in any event, their claim for rent post the change of the law, post the Court of Appeals clarifying what the law was. So clearly, those claims could proceed in Supreme Court, correct?
I apologize, Your Honor. I'm sorry. I didn't hear the first half of your
claims
sentence.
Post the change in the law could clearly proceed in Supreme Court, correct? Because the law has made clear that these kinds of claims now can be raised in Supreme Court. So the tenant would be entitled to raise those claims here, correct?
Post
change
of the law, they, I suppose, would be permitted to raise them, but.
So if with that concession, so you still want DHCR to consider the pre-EPTA claims? It doesn't make any sense to me that all claims aren't decided in one forum so that there's no inconsistency, et cetera, et cetera.
Respectfully, the appellants submit that the DHCR is the proper forum for the pre- and post-HSTPA claims with respect to the.
So in other words, we ignore what the Court of Appeals is instructing us.
In this circumstances, because they were told that they should be going to the DHCR by 2 justices of the Supreme Court, and they disregarded it and ignored it. They said, "Oh, thank you," and they didn't make a motion to renew or to re-argue. They did not appeal the decisions. They just ignored them.
So what happens here if you're right and you advance your rent claims against them, even though it would appear that the tenants have a merit with respect to whether the apartments were appropriately or wrongfully deregulated based on Roberts, et cetera. What's your answer here? That you just simply should win on summary judgment, and then what happens? Go back to DHCR after you award the landlord all this rent, and then they sort it out and determine whether they have a meritorious overcharge claim?
That's one, that's
That what you
that's
believe
one
should
option.
happen here?
I don't know where, I believe that the rent stabilization overcharge claims should be determined in the DHCR and have the, you know, and the respondents would have recourse afterwards to have an adjustment of the rent if there is an adjustment necessary.
So, counsel, I want to change the direction just a little bit. Could you address that prong of your motion that seeks use and occupancy, that sought use and occupancy, and the deposit of the rent arrears in the court?
Yes, Your Honor. We respectfully submit that that RPL 220 is not applicable in this case, as that statute directs use and occupancy as opposed to rent paid pendente lite, which is what appellant is seeking. There is still a landlord-tenant relationship between the parties, and they are subject to the contractual relationship. And while the respondents still have the opportunity in order to litigate their claims as to the rent, there is rent-stabilized leases that were submitted that are in existence between the parties, and they should have been guidance to the court for the submission, for the direction of the respondents to.
Okay, let's hear what your adversary has to say, and then you'll have a few minutes to respond. Thank you very much.
Thank you, Your Honors. Good afternoon. May it please the court, Jack Lester on behalf of the respondents. I believe your questions kind of hit the nail on the head of the issue.
How about my colleague's question with respect to use and occupancy?
Well,
why shouldn't there be a hearing on use and occupancy? You're occupying your
right.
clients are occupying the premises. Why, at the very least, why not a hearing on that issue?
Absolutely. And the hearing on use and occupancy should take into account all of the equitable considerations. And here, the last registered rent was in 2002 for 22.
Just a question. So you agree that there should be a hearing on use and occupancy?
That takes into account all of the equitable considerations. I don't think there could be any dispute about that, and we've never really disputed. We've been saying all along we should resolve.
So these prior decisions that said that the tenant's claim about rent stabilization should be adjudicated at DHCR, which whatever happens with that happens. So when the landlord now sues for rent in Supreme Court, why shouldn't that the failure to ever get an adjudication about this at DHCR bar the tenant from bringing up the issues which could have been litigated at DHCR, which weren't?
Well, I think the problem with that was that after we initiated the first case in Supreme Court in 2018, it was only then that the landlord provided a rent-stabilized lease. The landlord understood, based upon our action in 2018, that they had an obligation pursuant to rent stabilization. The problem was they set the rent at $4,800. And
that was the market rent, correct?
Right. So as a rent-stabilized lease, the last recorded rent was $2,222. Now, all of the Court of Appeals cases, all of the appellate cases say if you're not keeping a rent-stabilized registered record, and they hadn't.
So you're back at DHCR, are you not? And what happens there?
Well, I think the answer there is judicial economy, because are we forcing the tenants to pay a rent that would be in clear statutory violation based upon the record? The record shows there's no recorded rent for 16 years, that in 2007, when the tenant moved in, he was given a free market lease, and then in 2009, you had the Roberts decision. And this is a J51 building. So you had 9 years post-Roberts of free market leases. So to allow the landlord to benefit by their fraud.
I mean, I know that the current law says that there is concurrent jurisdiction between the Supreme Court and DHCR. And there's a lot of times where there is concurrent jurisdiction, but given, I mean, they do have a bit more expertise than certainly some of the Supreme Court judges in these rent stabilization issues. Should your issues go to to DHCR and the Supreme Court case be stayed while it spends the time doing that? Does that make sense, or is just that ridiculous?
That wouldn't make sense for what Justice Singh said, judicial economy. Let's get this resolved in one forum based on equitable principles, based on what the statutory scheme is, and let's resolve this. We have no interest in prolonging it. We want to...
Counsel, I'm sorry, you said fraud. I'm not necessarily sure it's a fraud. Your client moved in pre-Roberts, if I'm not mistaken, correct?
I'm sorry?
You said your clients moved in before the Roberts decision,
He
correct?
moved in pre-Roberts.
And you understand that before the Roberts decision, a landlord had a reasonable basis to rely on the DHCR's interpretation of the J51 laws to allow luxury deregulation, vacancy deregulation, while getting J51 benefits.
Correct. But
Correct?
Just
bear with me.
Okay.
Then we have Regina, and there's a whole line of other cases. So you can't be so glib and say there was a fraud on your clients. There may be an overcharge, but no fraud, Mr. Lester. Is there?
Well, I don't intend to be glib, but based on the record, you have the Roberts decision came down in 2009, which said you had to re-regulate J51. They ignored that. Then a few years later, the Attorney General issued a directive to all of the owners saying you must re-regulate. They ignored that, and it wasn't until 2018.
So you bring litigation about that and you're sent to DHCR.
I'm sorry?
You bring litigation about that. You have prior actions, and the end result of that is that you're sent to go to DHCR.
Right.
And what happens there?
Well, obviously, DHCR would, I believe, through an administrative process.
I mean, can you just decide, well, I'm going to drop what's going on at DHCR, which court decisions have sent me, have forced me to go there, and then I'm going to start all over again now in defense against the actions against me? I mean, how does that work? I mean, isn't the fact that you were sent to DHCR, doesn't that force you to be there?
Well,
as to those issues.
Yeah, but it wouldn't ratify the $4,800 per month, which is in clear statutory violation. And if you're seeking out a remedy in the Supreme Court, you cannot take the position that you're absolved from your burden of proof as to what the accurate stabilized rent should be.
Okay, thank you, Mr. Lester. Counsel, you have 2 minutes on rebuttal.
Yes, thank you, Your Honor.
So I think what counsel is saying is that when you come after him for the rent, in defense, he can bring up all of the issues that would otherwise be getting litigated at DHCR. Why isn't he right?
Well, I believe the question is why hasn't it, the DHCR is the determine what
You're suing,
was the
let's say,
determine
for a rent of $4,800 per month, which counsel says is clearly not a legal rent. So why can't the tenants in defense of that raise the fact that it's not a legal rent?
I mean, wouldn't this be something that would have to be determined at a hearing by the Supreme Court judge? I mean, you're seeking pendente lite use and occupancy, which does make some sense since they're the tenants. But we're not, we wouldn't necessarily be telling them that the 4,800 is the correct amount. Obviously, if you're going to have a hearing would be to determine all the factors.
Well, a hearing would be a hearing on the pendente. I apologize, I keep mispronouncing that.
Yeah, just
Use and occupancy. The rent would be warranted. However,
What about your
taking
main claims? What about your main claims? Why wouldn't they be permitted to raise this defense? Well, when you seek this rent to 4,800, it's clearly in violation of the rent stabilization law.
Right. I believe
You never won at DHCR, did you?
I'm sorry?
You never won at DHCR. DHCR didn't come down with a determination in your favor.
They never brought their claims to the DHCR.
You've never
it was
been
never
to
filed there.
DHCR.
We never received anything. If they have filed, we've never received it. And if they haven't, if they haven't filed, it's inconceivable why they haven't.
So what stops them from now, when you come after them, when they come after you for the rent, when you come after them for the rent, what stops them from raising the defense that this is not a legal rent? Why shouldn't they be permitted to raise that?
I believe it because they did not object to the legal rent in the proper manner, even before.
But they originally, I'm sorry, they originally sought to challenge the rent in 2018, correct?
Correct, and they were.
And what happened there is you offered them a rent stabilized lease at their last rent. It was 4,200, whatever it was, and you gave them the lease. But they were challenging that rent. They were challenging their status as free market tenants. They were challenging, based on Roberts, their right to have to pay the 4,200. So that issue was in place, and the court then said, okay, you probably have a good claim here, but we think DHCR is the primary forum to resolve it, correct? But they did come to court, just like you came to court. And then they came back in 2019, and Judge Perry read the earlier decision, analyzed it a little more than Judge Guest did, and came up with the same decision. Yeah, let the DHCR do it. But the bottom line is everybody came to court to try and resolve this, correct?
Yes, Your Honor, that's correct.
Okay.
Okay, thank you. Thank you
Your Honor.
both. We'll take a look at the papers again. The next case for argument is Harasnia versus Extel.
May it please the court, my name is Scott Singer, and I represent the plaintiffs' appellants in this matter. We know that a worker can obtain judgment as a matter of law under Labor Law Section 240, even if his claim is largely based on circumstantial evidence. In Angamarka, a decision of this court, the court held that the plaintiff worker was entitled to summary judgment where there was, quote, strong circumstantial evidence that he was, quote, probably injured as a result of violation of labor law.
So what's the strong circumstantial evidence, sir, in this case that would support that position?
In this case, the strong circumstantial evidence is, first of all, that at the time of the accident, the plaintiff was working on a completely exposed platform, that there were no protective devices above him.
Well, there was a net, but it was torn. Wasn't there a hole in the net?
Yes. Well, there's supposed to be two levels of netting. There's supposed to be a level netting below the loadout floor, which is where the erection was going on. That's like the 40th floor. There's supposed to be netting there. There was some netting there, but it had an enormous oval opening in it.
And how many floors was it above the deck,
Well,
the
he
diving,
was on the 25th,
was it called the
so
diving
it's
deck?
16. Most of the workers were on the 41st floor. Those were
He was on the 25th.
He was on the 25th. He was outside the 25th
Right.
and was outside the perimeter of the building. But there's also supposed to, and there, Mr. Bigley who's the project executive for Jill Bain, for the defendant, he testified that where there's this kind of a diving board situation, an outrigger, there's supposed to be a netting directly above that, like 2 floors above that. So there should have been one on the 26th or 27th floor. That was completely absent. It might have been there at the time, but it was pulled back. In any event, it was clearly not there. The plaintiff testified that the closest he saw was 10 floors above. So there was nothing directly above him, and the one below the loadout floor, which was the 40th floor, had this enormous...
And there were violations issued to the construction manager.
Yeah, to Jill Bain directly by Best and the Department of Buildings. And specifically for lack of protective devices.
Right.
So, and the plaintiff testified something hit him. He was bending over. It hit him in the back of his head. Now, look, of course, it's not absolutely certain that it fell from above, but it certainly is likely that it fell from above. And this court has held that if it's probable that was the cause of it, and it certainly was in this case, then that should be a violation.
Counsel, doesn't case law allow a 241 claim even if you don't know exactly what hit you?
Yes, it does. I mean, but I think the operative fact here is the absence of the overhead protection. That's what gives rise to 240 liability. If that would have protected him, and in this case it certainly would have protected him, then there's a violation because the protective devices weren't there.
So that's kind of the end of the story. That's kind of the end of the story.
Yes, I think it's the end of the story, and I think he should have been granted summary judgment in those circumstances. Unless there's any questions, I'll reserve, if there are any other issues that come up, I've reserved some time.
For rebuttal. Okay, that would be fine. Thank you, Mr. Singer. Counsel.
Hello, Your Honors. May it please the Court. I'm Francis Mann for the defendants. The plaintiff did not present the prima facie case on its motion.
There's no real serious issue here that the plaintiff was struck by something.
Well, we moved for summary judgment, and we're prepared to assume that that is a fact because we take him at his word in opposing our motion.
Does the fact that you don't know what hit you preclude you from getting relief under 241?
No, not necessarily. But when you don't know what hit you, where anything came, that anything fell, you don't know whether the object was being
Counsel,
secured.
I'm so curious about this, the theory that you're presenting, like you don't know. If you're struck on the back of your head and you...
He could have been hit by a baseball that somebody threw him. He could have been hit by a lunch.
He is on a 25th floor of
Your Honor, he could have been hit by somebody who was walking behind him and knocked him on the back of the head with a pipe.
But that's why I started out with asking. There isn't really a serious question here that he was hit by something on the job site, that something hit him in the head.
Yes, okay, and in Narducci, the court said.
So now then, the
you have to.
Wait,
if you
counsel.
don't know what hit you, does that mean you don't get 241 recovery?
That alone is not sufficient, Your Honor.
Really, even when you have, counsel, even when you,
been,
thank you, even when you have safety netting with a large hole in it, horizontal safety netting, A, that has a hole, B, that's way higher than apparently what it's supposed to be, where you have someone getting beamed on the head to the point that he's asked, can he continue working, and he actually is throwing up. I mean, I don't
no one
get
is saying,
it.
Your Honor, that he wasn't
don't get it.
struck. I've indicated that in moving for summary judgment, we accept that.
But no one
is
saw another person walk onto the platform or anywhere near walk
there
at
has
the
to
back.
be there has to be a showing that labor law 240 is triggered by
so
something
let me ask
other than somebody being struck.
Okay, fair enough. So in this instance, we're talking about circumstantial evidence, right? Because you've acknowledged that you don't have to identify the object. So plaintiff testifies that he heard forms being stripped from above.
Your Honor,
and then he heard a popping noise, and then he was struck in the head, and there's a hole in the net. Why is that not sufficient? Why aren't those facts sufficient to strongly suggest that the falling object,
Wait,
the falling
please
object
let
came from the forms that were being stripped.
Your Honor, excuse my enthusiasm, but if he picked up, and this is indicated by the case law, if he picked up an object, he said, I didn't see it fall, but I know that they were working with that up on the 45th floor. Then you can use circumstantial evidence. You'd have a basis for an inference.
So in other words,
if
if the object, he's on a,
he has nothing except I was bound.
he's on a platform, sir. He's on a platform on the 25th floor, and so in other words, for him to have a viable case, the object should have stayed on the platform. That's what the analysis is?
No, it was a large platform, unless it was a beach ball. Your Honor, there was no question of fact. There just simply wasn't fact. There's no proof that any violation caused his accident.
Well, in opposition for summary judgment, don't you need to lay bare your proof? So, I mean, just saying, well, maybe somebody with a baseball bat came, which has no, there's just anything is possible. You're just raising all kinds of things. If there was something significant.
It's in the nature of a 3211 motion, in that there's just no proof of a prima facie case.
So,
we
counsel,
can't disprove something that they haven't alleged.
Counsel, kindly don't talk over us. It's really hard. Thank you.
My apologies, Your Honor.
Thank you. So what my colleague is asking you is, did you meet your shifting burden of proof? And it doesn't sound like you're raising anything more than speculation, and it's not even speculation grounded in any deposition testimony or any photographic evidence of any kind. How are you backing up what you're saying?
There's no evidence there's no evidence that anything happened other than the plaintiff saying I was hit in the head. What evidence do you expect a defendant to come up with?
Okay, well, I don't think we'll answer that question, but thank you very much.
Thank you very much.
Mr. Singer, you
Thank you, Judge Kapp.
have a couple minutes.
I just want to point out that they rely on a Manzo case from the Second Department. They said you can't prove a violation of labor law if there are several equally plausible explanations, but there aren't any other.
Kind of why I asked, we're on a summary judgment motion, you got to come through with more than just
Right. It has to be
speculation.
something plausible. I mean, I guess it could have been a UFO or a drone, but I don't think those are plausible explanations.
Well, how about the point that you didn't make out your prima facie? Because I don't think they're really arguing seriously that there are issues of fact on their side. Their point is you didn't make out a prima facie because that object is nowhere to be seen, so we don't know where it came from, et cetera, et cetera.
I mean, he was hit. He testified he was hit. And
Is an unwitnessed accident, can there be summary judgment on an unwitnessed accident?
it's granted all the time. There's case law in this department, many cases holding that you don't need a witness to establish liability. And in this case, there's no dispute that he was hit, and there's no dispute that, that he was unprotected.
There was a hole in the netting.
There was a hole in the netting. So,
It's not that it's an unwitnessed accident, it's that it's an unwitnessed cause. The cause is unwitnessed.
well, but not really, because he was struck. That's what caused him to fall, and that's not contested. There's no other plausible explanation. So I think that's why he should have been granted summary judgment. Also under 241-6, because of it was an area normally exposed in the sense that everybody knew that there was a danger that something would fall on workers in that outrigger. So there's no other questions. Thank you very much, Your Honors.
Thank you both. Have a good afternoon. The next case for argument is People versus Sanchez. Good afternoon.
Good afternoon. May it please the court. Rachel Lindy with the Office of the Appellate Defender on behalf of David Sanchez. The resentencing court here had the rare opportunity to witness David Sanchez's immense transformation in the 5 years since his arrest, and it still handed down a harsh and excessive sentence. By the time he appeared before the resentencing court, Mr. Sanchez had progressed so greatly that he was literally unrecognizable. For the first time since he was 12 years old, he had made a serious commitment to his sobriety and rehabilitation. He had acknowledged that he had engaged in conduct with serious consequences that harmed multiple people in desperation to sustain a serious substance dependency that he had struggled with since he was 12 years old. He immediately regretted his
Didn't the
actions.
courts take into account defendant's remorse and his commitment to his rehab?
This was before the resentencing court, and of
But
course,
was it taken into consideration, I guess is the question.
it was taken into consideration, but the 15-year sentence that he received was nevertheless still too harsh, given.
Then how do we, okay, and it's a fair point, but how do we balance that against the acts that, as I understand, are committed against Asian people who are all over 60 years old? Isn't that something that we have to balance between the harshness of what the person did and his efforts to get better?
And we're not minimizing the seriousness of that conduct at all. And Mr. Sanchez never minimized the seriousness of that conduct either. He expressed profound remorse for his actions, and it was so great that multiple detectives commented on it. And not only that, but he's made this incredible effort at his transformation, even given a very, very difficult childhood, which also needs to be taken into consideration. Given the continued impacts that it's had on him, by the time he was 12 years old, he was already consumed with this substance dependency. He had been subjected to multiple instances of physical and sexual violence in childhood. He had been struggling with a lifelong seizure disorder that continues to affect him, and that's also, as well as mental health crises. I mean, he had, in the aftermath of that sexual violence, he attempted suicide by the time he was 12, and that was the first of several suicide attempts. And these issues continue to plague him now and continue to put him at disproportionate harm in his incarceration, which also impacts the severity of his sentence because...
So, counsel, what are you seeking by way of reduction? Because from my reading of the record, the defendant basically followed people into elevators, demanded money, and then hurt them physically within the confines of an elevator. And it wasn't just once, it wasn't just twice. How many times was it?
There were 4 instances.
Four incidents.
Yes, 3 of them happened within 3 days of each other, 2 of them on the same day. And again, this was very serious, and that's also, I think, why it's so important to recognize.
What are you seeking by way of reduction?
We believe that a reduction to 12 years would still be a very serious sentence for him to serve. He would, of course, have mandated 5 years post-release supervision afterwards, but would nevertheless account for his many mitigating circumstances, and as well as
the sentence which he received, which certainly a significant time, but it emanates from the fact, and this is a staple of sentences which are imposed, because of his prior record. Not only did you have, is it 4 or 5 different crimes here that this punishment is being imposed for, that this sentence is being imposed for, but is also his prior record. There are 5 victims in this case, and the sentence which is in front of us, but then you have his prior continuing course of criminal conduct. It's 1999, 2005. That's why he ends up with such a sentence.
Yes, Your Honor, and that's why it's so important to recognize that who he is today is not who he was before, and that's demonstrated by the fact that in his prior terms of incarceration, he struggled to stay sober even when he was in group treatment, and he quickly relapsed upon his release. And if I may finish my thought.
And he was 30 at the time that he committed these crimes, right?
Yes, and what we see here is this growth and maturity where for the very first time, even when he was ineligible to participate in substance use treatment earlier in his incarceration, he took the initiative to start his own peer recovery support group program, demonstrating not only his commitment to his own recovery that we did not see in the past and that led to his prior relapses, but also his desire to be a peer leader and a support which he can then be in his community. and I'll answer any.
Thank you. You'll have some
Thank
time
you.
for rebuttal. Thank you.
May it please the court, Brent Yarnell for the people. I'd like to clarify the record on one point. The defendant did minimize the seriousness of his crimes immediately after his arrest when he was interviewed by the police and then interviewed again by the prosecutor. In both of those interviews, defendant denied that he had possessed a weapon in the 4 burglary and robbery incidents. He also denied that he ever hurt anybody in any of the 4 incidents. Then, after having given detailed accounts of those incidents that omitted the violence and omitted the weapons.
There was video surveillance of a lot of these criminal interactions, were there not?
Yes, that's correct.
Counsel, if I may, the defense counsel, appellate counsel, argues that the defendant today is a changed person, and I'm sure you're familiar with his background, which has a lot of concerning information, right, with respect to suicide attempts, epilepsy, sexual violence, or very early exposure to crack and heroin. And what I would ask you is, to what extent do we take into account the argument that the defendant today is a changed person from the person who denied responsibility, let's say, for the full range of his wrongdoing?
Sure. So first of all, I mean, all those factors you mentioned certainly are mitigating circumstances. Because we're talking about his resentencing, the progress he made from the initial sentencing to the resentencing, I think is relevant to the resentencing. The question for this court is, did the resentencing court improperly assess the weight of those factors?
And why did the resentencing take place? Because?
The resentencing took place because his 1999 conviction for first-degree robbery had been thrown out because the court in Queens found that he had received ineffective assistance of counsel, and so he was no longer a persistent violent felony offender. He was now a second violent.
That was taken into account. It was reduced by 5 years, correct, at that point?
Well, it was reduced from a 20 to life indeterminate sentence to a 15-year flat sentence.
So in effect, how much was the reduction?
Well, it's hard to put an exact figure on it. I mean, you're right that it's a 5-year.
At least 5 years. At least 5 years.
At least 5 years, and I mean, I would say that the difference between a 15-year flat sentence and a 20 to life indeterminate sentence is just more than 5 years.
So it's 5 plus.
5 plus, yeah. I think it's a very significant, considering that the top end of his initial sentence was life. I think a 15-year flat is really a...
And the 15 was with respect to the the counts for burglary and robbery, but with respect to the assault count, that was made it was all concurrent, right?
It was all concurrent. I don't remember what happened with the assault count. I certainly know that the initial assault sentence was 7 years, so it was lower than 15 anyway, so I don't think it affects the total sentence. And I think the sentencing court just properly balanced all the mitigating circumstances here against the fact that these were extremely serious crimes. They were violent crimes. He punched a 65-year-old man in the face. The man fell down the stairs. He broke his knee, required surgery to his knee. He had a cut on his eye. In another one of the incidents,
He also admitted targeting Asians, didn't he? Because he thought they would testify against him. Isn't that what he said?
He admitted that was what he was doing in his 2005 crime, and the 2005 crime is just virtually identical to this crime. So our inference is he said that he was deliberately targeting Asians when he committed a series of incidents against Asians in 2005. When he again commits a series of incidents against Asians in 2014, we're inferring that he had the same plan, the same intent. Unless there are further questions, we ask that you affirm. Thank you.
Thank you.
Thank you. So to clarify first regarding the allegations about minimizing, I just do want to point out that Mr. Sanchez took full accountability for the harm that he caused. At plea, he was upfront about using a screwdriver. At resentencing, he specifically apologized to the people that he harmed and sought their forgiveness. Demonstrating as well this growth that he made in that time. And in addition, the 5-year reduction that you did notice was not sufficient to account for not only all of the ways in which he changed, in which he had made this commitment to his sobriety and expressed an effort to a desire to enter into inpatient intensive substance use treatment upon his release, which he's never had the opportunity to do before in his life, and which a further reduction in his sentence would allow him to do sooner, and have that continued support and structure without the disproportionate harm that he has faced in his incarceration and continues to be at risk for.
Hasn't he spent most of his life incarcerated since about the age of 14?
Yes, in part that's due to the fact that his attorney in that later vacated sentence had made an error, and where he was supposed to have been put into inpatient treatment at that time, he instead.
So how long was he out before this 2014 situation occurred for which he's being sentenced here? I mean,
it was about 6 months. He had, and again, he had struggled to stay sober previously while he was incarcerated, and then was more vulnerable to relapse, which is not the case here now, because he has made this renewed commitment to his sobriety. He's made this expressed effort. And so in view, again, of his disabilities, his deep remorse, and his demonstrated rehabilitation, including his commitment to his sobriety, as well as his disproportionate risk of harm of prolonged incarceration, we ask that you reduce his sentence in the interest of justice. Thank you.
Thank you. Thank you very much. Thank you both. The next case, Murphy versus Chinatown Cardiology. I believe we just have the plaintiff appellant here, correct?
Yes, Your Honor.
Okay.
Good afternoon. May it please the court, Michael Cassell, Hogan and Cassell for the plaintiff's appellants, Karen Murphy and the estate of Francis Murphy. As we set forth in our brief, the Supreme Court erred in finding no proximate cause here. I know there's no adversary. I'll make it very brief. Just the main issue, the main argument is once the court essentially found, at least, for purposes of summary judgment, as I read the decision, is a question of fact as to whether or not the defendants perforated Mr. Murphy's right renal artery. What happened at Valley Hospital cannot basically end the proximate cause.
There can be more than one proximate cause. Is one
of course, and the Mazzella case says, basically, if it set forth a chain of events, Valley Hospital's job was to repair the perforation. The only way defendants get out is they show it was extraordinary, not foreseeable, far removed. They don't put forth any evidence as to that.
Why didn't you bring in the hospital?
Oh, great question. The hospital, we don't believe we had jurisdiction over them because they're located only in New Jersey. That was the issue. So we figured we'd just go after the initial tortfeasors. Any questions? Thank you.
Okay. Thank you, counsel. The next case for argument is Satterfield versus V-Stock Transfer.
Good afternoon. JT Singh from Singh Law Firm on behalf of the appellant and the sponsoring attorney. I'm going to hand the podium over to Mr. McCracken, who's admitted on Pro Hoc Vice to handle argument.
He's been admitted, is that what you said, Pro Hoc Vice? Okay.
Yes, Your Honor. Thank you.
Thank you very much. Good afternoon, counsel.
Good afternoon. May it please the court, Michael McCracken on behalf of defendant appellant Val Sklarov. We are appealing the order of the finding of civil contempt in this matter. The defendant was required to turn over shares of a certain company. During that time period, when the order was entered, the holding company went into insolvency.
Yeah, but your client was directed to turn over these shares as early as 2021, well before Dolphin went into insolvency, correct?
I do not know if that is before the time that Dolphin went into insolvency, but that is entirely possible. But the issue here is whether or not at the time that the civil contempt order was found for him being unable.
You didn't appeal the contempt order, correct?
We are appealing the June 2nd order.
Did you appeal the contempt order?
The contempt order is not being appealed.
Well, then how do we reach what you're essentially arguing is that the contempt order was wrong?
The contempt order is not necessarily wrong, Your Honor. When a contempt order is entered, the burden then shifts to the defendant or to the person being held in contempt.
Could you slow down just a little bit?
Excuse me?
Could you slow down
Yes,
just a little bit, please?
Yes. Once a contempt order is entered, the burden shifts, a civil contempt order is entered, the burden shifts to the person found in contempt to determine whether or not they can purge. When we are appealing the order where it found that he was in fact able to purge but failed to do so, and that is the June
So why
2nd,
can't he purge his
2023.
contempt?
The reason why he cannot purge the contempt, which was admitted by the attorneys for the plaintiff in this matter, was because of an insolvency proceeding where the stock was being held. And pursuant to that proceeding in Britain, they were...
So why isn't it possible for him to arrange some sort of an accommodation with where the stock is being held in insolvency? Because it's the brokerage that's holding the stock that's insolvent, right?
That is correct, Your Honor.
Right? So why can't he reach an agreement with whoever the administrator of the insolvency is, which is in the United Kingdom, right?
That is correct.
Why can't he reach an accommodation with them to get that stock released?
Yes, if you recall in the appendix, there was an order that was entered by agreement between the parties in February, where both parties stated that the rightful owner of the stock was the plaintiff and that the brokerage firm was required to, to transfer the stock to the plaintiff. They've refused to do so. If they are refusing to do so pursuant to the court's order, I'm not sure what else more he could do.
Well, what stops you from going into court in the United Kingdom and getting an order transferring the stock, saying, come to the court and say, look, if I don't get this stock transferred, it may be in my name, but it has to go to someone else. If I don't get it transferred, the person's going to be in prison. Why can't you go into court in the United Kingdom and accomplish that?
Well, I suppose that they could move in a court in the United Kingdom to go ahead and do so. I'm not sure that the heroic effort of that is what's necessary to show that they're unable to purge.
I'm sorry, wasn't there something of record where counsel for your client, Mr. Means, and another person who put in affirmation below to try to describe the process by which to get Dolphin re-registered?
Yes.
The problem is Dolphin was thrown out because of insolvency. So the issue is how do we get Dolphin back into corporate existence, so to speak? And wasn't it a question of how to go through that process and possibly pay certain taxes? And there would be a way to do this and expedite this, but we don't have any real process except conclusory statements from counsel about this.
Yes.
There's as my colleague was pointing out, there's a way to do this, to get Dolphin back in and then eventually get the stocks transferred.
Right. My understanding is that Dolphin is the holder of the stock. The holding the person who was named with the interest in the stock at Dolphin was America 2030. That was the entity that had been stricken off of the registrar for its failure to pay the corporate taxes, which was needing to be to put in good standing, which actually did occur. And so that did in fact happen. The point that we make in the appeal is that the June 2nd order, which finds him not purging, fails to take into account admissible evidence pursuant to the admissions of the plaintiff's attorneys that states that they could
So
not.
what's your response to what Judge Masley said in her decision? There's no basis for the court to find these statements made by either Steffens or Means reliable. There was no affidavit from either Means or Steffens on the penalty of perjury. There's no order appointing Means or anyone else as Dolphin's liquidator. There is no evidence that Singh attempted to obtain an order or its British equivalent by the UK court stating that plaintiff CODX shares cannot bypass the insolvency proceedings despite the courts and arbitrators' numerous orders, some issued before Dolphin's insolvency. What's your response to that?
Yes, my first response to that is that we are not making any contentions concerning the admissibility of the evidence submitted by the
Can you move the mic up because I'm having a hard time hearing you?
And can you repeat the last thing you
Yes.
said?
We are not making any sort of contention concerning the admissibility of the evidence that was stricken by the trial court that was submitted by the defendant. Our position is that when they make the contempt
But
order,
isn't this what Masley finds insufficient in your evidence? And why isn't that a valid insufficiency to deny you the relief you seek by this appeal?
because in addition to the evidence that was submitted in support of by defendant and his attorneys, there is also the admissions by the plaintiff, which is what was ignored in the ruling by the trial court. At no time in the trial court does the trial court address the admissions several times, both in sworn testimony by the plaintiff's attorney during the hearing, on the April 1st hearing, and in other submissions in writing, that in fact the accounts were frozen and they cannot be transferred. So it's that evidence alone that we seek to have the order overturned, because it's an admission by the plaintiff's attorney that in fact it could not be transferred.
Can I ask another question?
Okay. Okay.
Counsel, it's my understanding or our understanding that the whereabouts of your client are unknown, is that right?
That is correct.
And why should we entertain the application of a person who refuses to appear before the court and who has defaulted repeatedly, notwithstanding numerous opportunities for him to appear?
I believe that people should follow court's orders, and when courts order people to appear, they should appear. I'm a firm believer. When I tell my clients, I abide by court's orders. But again, the point is, was he able to purge? And in this case, the admissions by the plaintiffs stating that he, in fact, was not able to purge due to the inability to transfer the shares is the only one that's at issue here. Now, the trial court certainly could have done other orders of contempt in this case, but she did not, and those are not up for the appeal here. The appellee makes the issue that, well, look, he's had all these other issues of orders that he hasn't filed. Let's just keep this order. Well, that would transfer this civil order into a criminal contempt order.
Okay, you have some time in rebuttal.
Thank you, Your Honors.
Thank you.
I would like to, may it please the court, it's Ann Salisbury from Guzalv LLC, representing the respondent, Brent Satterfield.
So is it true that you've admitted, or your client has admitted, that the shares can't be transferred? And if that's true, why shouldn't the defendant have relief from this warrant of arrest?
It was I who was testifying under oath in the hearing, and it was not an admission that it cannot be done. There was a 2019 period where they just didn't do it whatsoever, did not order the transfers. Then at one point, it was time they were going into insolvency, but their entity hadn't paid like $100 tax in the UK. They wouldn't pay the tax. Then, under court order...
When you say their entity, which entity?
I'm sorry, there were several entities. Val Sclera's company, they all have almost the same name. America 2030 LLC, America...
The defendant isn't also the broker in the United Kingdom.
No. The UK entity that Mr. Sclera transferred the shares to, some of the shares, a big chunk of the shares were here in New York. And this is important to the judge's order because she cites this email. 1 million shares was sitting at the transfer agent, V-Stock. 1 million shares were sold, never to be seen again because they went offshore. And 200,000 shares were found at Dolphin. During this procedure, after they had been ordered many times, just sign a simple form to turn over the 1 million shares. Val wouldn't do it. And an email was sent to me, this is cited, it's in the record A164, saying, we'll cooperate transferring the 1 million shares if you give us the 200,000 shares. They've already been ordered to transfer all of them because he was found to have defrauded the Mr.
What would he need to do to purge himself of contempt now?
He needs to get the shares transferred.
How many shares?
200,000 shares sitting in the UK.
So did you concede that he's incapable of transferring those shares?
Not that he was incapable, that certain events, as he continued to not comply, there was deadlines. There was a 1-year period where if you'd set up an account, they would just transfer it.
Today, if he wanted to, would it be possible for him to transfer the shares?
I'm sure he has to, they're sitting there. I'm sure he has to make some kind of claim against the receiver. He didn't do the basics. They would automatically have been transferred if he'd opened an account. But I know you're asking about the future. My first answer went to, did I admit that they can't be done? And I did not. There are hurdles, and those hurdles grew.
But he's made no efforts to try to jump those hurdles to get to the end.
He was going to testify as to why he couldn't do it.
But he did not appear.
He did not appear, and he said he was in the Ukraine and he was in the Maldives, and then he didn't show up at all, and he gave some other excuse about
Didn't the court say he could appear virtually or no?
Yes.
So it didn't really matter where he was, he could have appeared virtually.
Right.
And was there an affidavit allegedly notarized in Pennsylvania when Mr. Agios?
That's right. The first affidavit that was submitted was notarized in Pennsylvania. When we inquired further, they said he was overseas, but said that because he's a Ukrainian national, the Ukrainian war was preventing him. Then the judge asked directly, where is he? And the counsel responded, Maldives, not Ukraine. And there were mounting problems leading to her order. It does not shock the judicial conscience. It's not an abuse of discretion. It's within Justice Maisley's discretion after many, many orders of total defiance of her orders.
I was surprised, I must say this as an aside, that the orders were not part of the record that was presented to us. I had hoped to see all of them there.
Understood.
Thank you. Counsel, you have 2 minutes of rebuttal.
Yes. Yes, as pointed out in the brief and in the reply, there's testimony that was presented through the appendix and the record on appeal that was presented where we are alleging that they have made these statements that the accounts are frozen, they can't be transferred.
What caused the insolvency?
I believe that it was Dolphin, who is an unrelated entity to all of the parties, had too many liabilities for the amount of assets that it was holding.
So your client essentially caused the insolvency?
No. With Dolphin?
Yes.
No. With Dolphin, no. I don't believe that he would have caused the insolvency with Dolphin. Dolphin is the holder of the stock, and he deposited the shares of the stock at Dolphin. Yes, I'm not sure what the insolvency is, but no, him having the stock there did not cause the insolvency, is my understanding. I don't think that's ever been alleged by anybody, to be perfectly honest. And again, back to there could be lots of contempt orders that could have been entered, but there's the one that we're here for only today, and that is the civil contempt order. And a civil contempt requires the contemptor to hold the key to his release. And if he can't purge himself of it, then...
But it's not clear to me. It seems to me that maybe he can purge him, he can take steps, or at least explain to the court the steps that have been taken, and maybe more steps can't be taken. But at this point, has he really taken any steps to resolve the insolvency to get the shares back?
Well, I don't believe there's anything he can do to resolve Dolphin's insolvency. Dolphin and the parties are totally unrelated, and I don't
He
believe
doesn't
that.
have to resolve their solvency. He has to just find a way to arrange to transfer these shares. That's what he has to do. He doesn't have to fix the insolvency.
Right. Well, again, the order there was I believe that those steps have been taken, to be perfectly honest, based on the record that's been presented, and that includes the February order between the two parties, agreed order, which states that the correct owner of the shares are plaintiff. They should be immediately transferred to plaintiff. It's addressed to Dolphin.
Well,
it's signed
I'm
over by the
sure
trial court.
more than that needs to be done. That's probably part of the problem.
And if you just, obviously...
You just finish up, yeah.
Sure. And, one of the evidence that is submitted there is the testimony through the deposition transcript that was incorporated into the June 2nd, 2020.
I'm sorry. You claim that Dolphin has absolutely no relationship, corporate or otherwise, with Mr. Sklar?
I believe that is my understanding.
My understanding, and if I'm wrong, is I think it's in the record, the Dolphin account is in the name of one of Sklar's entities in the United Kingdom, the entity that have been deregistered. Isn't that a linkage?
No.
Isn't that some control that risk forfeiture of these shares to the government?
No. My understanding is that the shares are in the beneficial name of America 2030, which is a corporation that is affiliated with the defendant. That the shares are then deposited to Dolphin under the name of the related corporation. But there is no sort of control or anything concerning America 2030, any of the defendants, or the immediate defendant with Dolphin, which is a brokerage house, is my understanding.
Thank you.
Thank you.
Thank you both. Warburg Realty, I believe just the appellant is here.
Good morning, Your Honors. Errol
Good
Margolin.
afternoon.
Margolin and Pierce for the appellant. I'm going to be very brief. My point is that a real estate broker is entitled to be paid fairly for their services, and that's not what happened in this case.
But isn't there a contract here, sir?
Excuse me?
Is there a contract here which governs the relationship between these parties?
No, I'm not proceeding. The contract is not a bar. I know it's been raised.
So in other words, you can proceed on your common law remedies even though there's a contract here?
The contract does not prescribe that if in the future this particular purchaser comes back to the real estate broker and the real estate broker.
deal with that situation that there's a 90-day period in which the broker would still get a commission, the clear inference of which is that after the 90 days you don't.
Well, after the expiration of the agreement, that particular purchaser could have gone to the seller or to any other real estate broker and purchased that property. But that's not what happened here. This particular purchaser went back to the real estate broker, and the real estate broker went to the defendant's attorney, and put the same deal back on the table. The sellers accepted that particular purchaser.
So
and
was there a
closed.
deal made by the attorney and was there a deal made by the attorney with the broker then? Was a deal made by the attorney for the seller with the broker to pay a commission if the deal goes through?
Well, I think it's implied. We're alleging this is an implied contract. The seller's attorney, I've alleged, acted in...
Actually, the relationship was quite raw at that point, and the lawyer said...
Well, they weren't speaking, that's true. And the seller's attorney...
Specifically said, don't call the clients, let me deal with it.
let me deal with it, I'll take care of it. If this deal is going to happen, everything will be fine, you'll get paid your commission. That never happened.
Well, I don't know if she said everything will be fine, you'll get paid your commission. I
Well-
mean, that's what your client alleges.
You're correct. I don't know what she said. She said what she said in her email. The email is before the
That we
court.
saw, yes.
My client relied on that email, took no further action, and assumed there was no deal and that they were not accepting that purchaser. And then my client found out about it in the real estate transfers.
Okay, well, we'll read it through. Thank you for coming.
If I could point the court just to two decisions. I think the Spree decision and the Gluck decision, Spree decision in 2014 and the Gluck decision in 2018 really address this particular point. And I don't think that the court, or the IAS court, failed to consider those.
Okay, we will certainly take a look, and again, thank you.
Thank you.
Counsel. Have a nice afternoon. The next case for argument is People versus Juan Silva Santos.
Good afternoon. May it please the court. Elizabeth Vastley on behalf of Mr. Juan Silva Santos. The waiver of the shock program as part of Mr. Silva Santos's guilty plea was illegal and in contravention of the corrections law. Respondents
Are you
may...
arguing it's an illegal sentence? What are you specifically arguing with respect to waiver of the shock?
Yes, Your Honor, that it is an illegal sentence, that it is not something that could have been ordered as a part of his sentence or bargained for in the plea agreement. Respondent's main argument appears to be that Mr. Silva Santos is not eligible for the program, but that was wrong. Mr. Silva Santos is eligible. Respondent appeared to be relying on an older version of the statute, but plainly per Corrections Law 865 sub 2, he would be eligible, is eligible, but for this illegal waiver. And this is not a case where there was court-ordered shock at a time where the individual was not yet eligible. And the DLRA specifically made that possible for those who are eligible, like Mr. Silva Santos.
So it's illegal because it usurps DOC's authority? I mean, what's the illegality?
Yes, Your Honor. The corrections law for years said that the shock program is in the authority of DOCs and that they assess the individuals and they choose who they want to admit to the program and who they don't want to admit into the program. And there are cases from across the state that have said this is DOC's purview, courts stay out of it, you can't put it in a plea bargain. In 2009, the Drug Law Reform Act added a very narrow exception, which was that courts could order shock, and this was just only to expand people in shock. They wanted to reform the drug laws. They thought it was a good program. They thought the more people, the better. We'll carve out this narrow exception. But nothing about that exception said that docs couldn't keep doing what it was doing. And the correction law still stands. It still stands the way it was. Nothing in the DLRA said that, changed anything.
So you're saying that nobody is allowed in making a plea bargain to waive the defendant's right to go to shock? I mean, those are all illegal sentences?
Yes, they are, Your Honor.
Isn't that done somewhat regularly?
It has happened, but it is not proper and it's illegal. And, in the same way that we wouldn't let defendants waive minimum term of parole for indeterminate sentences, or we wouldn't.
What about, sort of by analogy, if we accept that argument, couldn't you argue that all appeals waivers are illegal sentences too, because you're taking away from the appellate courts certain disputes, but obviously reserving other disputes? Wouldn't the same argument hold true?
It's different, Your Honor. Appeal waivers, there's no statute like there is with the corrections law that gives docs this power, and it's still all within the ambit.
Doesn't it usurp our power? Our power is usurped, right? In that instance, correct?
It is still all the judiciary, Your Honor, and in the same case where the docs is in the position to look at individuals in confinement and make that determination, and it's akin to the other areas that these courts have said you can't bargain away. You can't bargain away minimum term of parole. You can't bargain away good time credit. You can't bargain away all these things, that it's just better for docs to make that determination.
So putting aside your claim that the Department of Corrections has exclusive jurisdiction to determine the shock program, there's still criteria to be eligible for the shock program. And the Corrections Law 865 pretty much says that the determined prison term has to be, among other requirements, eligible for conditional release within 3 years. Your client was sentenced to 7 years, right? So obviously, as a matter of eligibility, whether the court could or could not consider that as part of the plea, your client would not be eligible. Yes or no?
He is eligible, Your Honor.
How is that? Based on the express language of the correction law?
In the express language of the correction law, that's 865 sub 2, it says that people can be selected into the program either at the reception center or at a general confinement facility when the otherwise eligible incarcerated individual then becomes eligible for release on parole within 3 years. So even if he's not immediately, quote, eligible at the time he first becomes incarcerated, when he nears that end of his sentence, at the end of 3 years, he then becomes eligible.
So is he near the end of his sentence?
He is, Your Honor. His conditional release date, as a respondent agrees, is 2026 in July. So at this point, he is eligible, but even if he weren't, he should be able to apply for this program whenever he becomes eligible per the statute, and respondent's brief to the contrary about eligibility was incorrect. I believe they were relying on an old statute. If there's no further questions.
All right, you'll have a few minutes on rebuttal. Thank you, counsel.
Good afternoon, Your Honors. May it please the court, Andrew Seawald for the people. I would point out in Corrections Law, Section 867, that details the procedure for selection of participants in shock incarceration programs. And the first step in the procedure is for an eligible incarcerated individual to make an application to the Shock Incarceration Screening Committee for participation to participate in the shock incarceration program. So it's not as if corrections just plucks people whether they are applying or just because they're eligible for shock.
So your point being is that if he has to apply for it and it starts with him, he can agree to waive it.
That's exactly right, Your Honor. So, and that's what happened here. And And it's important to just take a step back and realize that the original charges the defendant was facing would have made him ineligible for shock because he was facing A1 felonies. So he was ineligible, and it was only he only gained potential eligibility by virtue of a plea bargain, and that the people were willing to allow him to plead to that lesser charge. But as part of that plea bargain, he had to give up his right to seek shock incarceration.
If it's part of an illegal sentence, then presumably he would have the right to seek it, correct?
Correct, but I think as Your Honor asked of my adversary, there are all sorts of things, including a waiver of appeal, that all sorts of rights that a defendant might waive as part of a plea bargain. And the shock incarceration statutes make clear that shock incarceration is a privilege, there's no right to it. And so the defendants routinely waive much more significant fundamental rights as part of a plea bargain than any privilege of participating in shock incarceration.
By way of background information, the program's approximately 6 months long. How long is shock?
Yeah, I think that's right, that it's about 6 months long.
And upon completion, the person is immediately eligible for parole?
That's correct, Your Honor.
So it would shave off 2.5 years from 3?
That's my understanding, yes. And so given the seriousness of the charges the defendant was facing here, the seriousness of his conduct, what appeared to be a very large-scale heroin and fentanyl operation that he was running, that's why the people would have been unwilling to accept or offer him a plea bargain that would allow him to serve potentially so little time in prison. And if there are no further questions, I rely on the brief. Thank you very much.
Thank you, counsel.
The shock program is very rigorous. It's not easy. And it's something that the legislature clearly wanted to expand participation in. We're not saying Mr. Silva Santos is going to get it, but if Docs really thinks that he is eligible, and that should be something that we would want people to work towards while they're incarcerated. I'm going to be on really good behavior, so I'm going to get shock. And it's not proper for courts and DAs.
It's supposed to start with an application from the defendant. Why can't he waive that right to make that application?
It's still a means to an end, Your Honor. It's still prohibiting people from participating in this program. You could also say it's illegal to say a person can't apply for parole at the minimum.
Do you agree that it does start with his making an application?
It does, Your Honor, but that doesn't change the entire concept still running afoul of the law and what we would want to encourage people to do here. DAs and courts can't just tack on all these conditions in a situation where 90% of cases result in pleas, and a lot of the times defendants take the pleas and they'll take it whatever is put in front of them, and to just tack on a lot of these situations and determinations that are better for docs, which they're strict. They won't let someone go into shock if they don't think they deserve it. And it's more proper for that to be within that ambit. And that's what the law says and the way it stands. And so this was an illegal sentence, and this court should strike that sentence, that waiver from the sentence. If there's no further questions.
Thank you. Thank you both. And our last case for oral argument, People versus Rockford.
Good afternoon, Your Honors. May it please the court. Nicole G. Douglas for Appellant Deshaun Rochford. Mr. Rochford's Level 2 participation was exceptional within the context of the clinician's time at Great Meadow Correctional Facility. Those are the words of Mr. Val.
Did he have any infractions while incarcerated?
Yes, he did have infractions while he was incarcerated.
Quite a few, no?
Yes, he did have
Some of them serious.
Some did involve serious charges, yes, or excuse me, serious allegations.
And also, wasn't this particular offense committed just within 2 months of when he was last released?
He was on parole for less than 2 months at the time that the offense occurred in the early 2000s, when he was 21 years old, yes.
So, counsel, of course, the purpose of SORA is to protect the community, right?
Yes, Your Honor.
More than anything else.
Correct.
The facts on this particular appeal are really heinous. I mean, it's a horrible, horrible situation. How is the community protected? You're talking about mitigation. Where is it?
The mitigation includes Mr. Rochford's exceptional response to treatment, his enduring support system, and his deep remorse and shame and maturity over the 15 years that he was incarcerated.
He hasn't been out, well, obviously, he's been incarcerated, so he exhibits what you're characterizing as good behavior, notwithstanding the infractions. But that's all while he's incarcerated. What do you offer to indicate that the defendant's behavior would remain crime-free, sexual offense-free once he's out?
So in any case where a downward departure is being sought, the court will face that same question. And to assume that conduct while incarcerated, evidence from treatment and evaluation by a dedicated social worker does not...
Basically, a case comes down to the fact that Mr. Valley sort of gives him a great report. That's what you want us to use to put aside the seriousness of the crime and the numerous infractions.
I'm not asking, and Mr. Rochford is not asking, to put aside the seriousness of the crime or to put aside anything, but to correctly weigh his risk of reoffense against the aggravating circumstances.
So what's in your favor in asking for that evaluation is what Mr. Valley has to say.
Yes, a clinician who evaluated his response to treatment, which is provided to individuals in the hopes that it will reduce their risk.
Does his evaluation overcome the factors which mitigate against the defendant's position?
Yes, it does, particularly when you take into account the modest request that's being made from a level 3 to a level 2. Your Honor, you asked about the protection to the community. It certainly serves the community much more if Mr. Rochford is able to, for example, live with his wife, as opposed to being required to live in a homeless shelter because the collateral consequences of the level 3 and the only difference between the level 3 and level 2 being that he's restricted into very narrow areas where he can live, and he verifies his address every 90 days. Whereas as a level 2, he's still required to report where he lives. He still has 20 years of post-release supervision, but he can live in a supportive environment and reintegrate into the community in an effective way. That serves the public much more than harshly classifying him as level 3 based on the past conduct.
Thank you, counsel.
Good afternoon, Your Honors. May it please the court, Noah J. Sexton for the people. To be blunt, Your Honors, the only thing exceptional about defendant's record is that it's exceptionally terrible. Defendant, again, less than 2 months after being released for another violent felony offense, while high, admittedly, commits a literally unspeakably heinous offense, a rape of a mother. He immediately goes to prison after his sentencing and proves himself to be nothing but a terror. He has 8 Tier 2 offenses, 9 Tier 3 offenses, including offenses for gang violations, weapons possession, possession of altered items. He spends the bulk of his time in prison not doing what's expected of him.
What about Mr. Valle's report? And how does he get to that report, given the facts that you're stating on the record now?
And I think the people are not trying to contradict the fact that, yes, towards the tail end of his sentence, when all the eyes were on him, he did well in treatment. Mind you, other than this one person's assessment of him, there isn't really anything else to support that. But even so, we have to remember that this is a balancing test. Even in light of all of the mitigating factors, we have to look at the aggravating factors. These aggravating factors are almost impossible to overcome.
Can I ask you, is counsel correct in her statement that the only difference between level 3 and level 2 is the restrictions on the living arrangements?
That's the biggest one, but again, that is linked to concern for the safety of the public. In this situation, defendant has already proven himself to be at least a recidivist felon. He has not committed any other sex crimes, but he committed a violent felony right before he did this. Frankly, these residency restrictions, which are mainly focused on keeping him away from high-risk areas like playgrounds, schools, things like that, are necessary because defendant has not shown in the actually less than a year and a half he's been out of prison that he's not going to reoffend. And if he reoffends at this level again, God forbid with a child or a disabled person, the damage is incalculable, incalculable. There's already 1 or 2 lives that have been ruined in this situation. By setting him as a level 3 sex offender, we're making sure that he does not do it again.
I think it would be 3 lives in this case.
3 lives, yes. If he, after this short of a period of time, feels that he is somehow entitled to any kind of modification of his status, Corrections Law 168.0 provides him with the ability to petition for an annual consideration of modification. Correct. But right now, it is totally unnecessary and arguably inappropriate to grant a downward departure in such a serious, heinous case. If you have no further questions, I'll rest on the papers.
Thank you. Counsel, any rebuttal?
Mr. Rochford does not rely simply on Mr. Valley's evaluation of his response to treatment. He also put forth letters of support from his family that showed the changes in his behavior and in his outcome. From the time he enrolled in treatment, he incurred no additional disciplinary infractions.
But you know, this is a man who has essentially spent his life in prison, which may be unfortunate, under strict supervision, right?
Yes.
And the only time when he was out, 2 months, within 2 months, he committed those infractions. So in weighing, I'm having a problem weighing it the same way you're weighing it, and I'm just wondering how you believe that the mitigating factors under these circumstances outweigh the aggravating factors.
I think you need to, I think it is instructive to look at the context and the change in context and circumstances between the time that the offense happened, when he was 21 years old, released from prison. He admits himself was immature. He was not...
Did he gain maturity in prison?
Yes, he did.
But then why all those infractions?
Because he was not perfect, and he's not attesting to being perfect. He's growing, and all of those infractions occurred before he began the deep introspection that he underwent while he was in treatment.
8 Tier 2 and 9 Tier 3 disciplinary infractions. That's a lot.
Yes, it's not an insignificant amount. It is over the course of 15 years, and the things that you can get infractions for in prison, while some of his infractions were concededly serious, he also received infractions for encounters with other incarcerated individuals where he was defending himself, and he put forth evidence of that. You can also get a Tier 2 infraction, for example, for violating a direct order. And so you also have to take that information into context when considering the totality of the circumstances.
Okay. Thank you. Thank you both.